Uncommon victim or common criminal? Patricia Hearst. Patricia Hearst was a 19-year-old sophomore at Berkeley when she was kidnapped at gunpoint. Around 9 p.m. that evening, two men and a woman approached her in her apartment, dragged her into a car, and drove off. She was the daughter of Randolph Hearst, one of the wealthiest men in America and the heir to the Hearst publishing dynasty. He was the owner of the national chain of newspapers, radios, and TV stations. 3 days after the kidnapping, the kidnappers, known as the radical group SLAs, were holding their daughter as a prisoner of war. She would be killed if anyone interfered with the group's activities, and all requests from the SLAs must be published in all forms of media. 5 days after the initial communication, SAL delivered a local radio station a recorded message from Patty demanding a ransom of some sort. On April 3rd, the SLAs issued a recording from Patty stating that she had the choice of being released or joining the forces of the SLAs. She denied her choice of freedom and wanted to fight for all the oppressed people she has chosen to fight. The next message we would receive publicly would be the videotapes and surveillance of the robbery of the bank in San Francisco on April 15th. The SLAs took credit for this robbery, and they got away with $10,660.02. Law enforcement official Attorney General William Saxby released a statement at a press conference. From what he sees, Patty was not a reluctant participant, but in fact a common criminal. 1 month after this, Patty shut up a storefront at a sporting goods store in order to aid and escape two other SLA members who were being arrested for shoplifting. 1 day after that, the LAPD were aware of the presence and surrounded the SLA's hideout. Gunfire erupted and the home blew up, killing 6 SLA members. Patty and the other 2 involved in the prior day's shooting never returned to the home. The 3 fled across the country to Pennsylvania, but returned to California in the fall of 1974. Once back, SLA members and Hearst robbed 2 more banks. 1 year later, after that, SLA members planted bombs in the Bay areas. On September 18, 1975, a group called SWAT stormed the house that Patty and other SLA members were living in. Hearst again would be removed forcefully from her home, but this time on totally different circumstances. The FBI agents asked her, "Are you Patty Hearst?" She replied yes before being handcuffed and arrested. This ended the most extensive manhunt in the U.S. history of law enforcement. During the time of her booking, she clenched her fist in a revolutionary salute. She stated to the booking officer her usual occupation was urban guerrilla. The evidence in this case is the communication in the forms of voice recordings of Patty and the members of the SLA and video and audio surveillance. Charged with robbery, initially represented by a team of lawyers, Hearst suggested that in her defense, she would establish some sort of temporary insanity along with her lawyers. The first defense team used strategies talking about the awful conditions of the early stages of captivity. The court appointed a team of psychological experts, found her sane but emotionally impaired to a significant degree. The term concluded that Hearst suffered from PTSD and needed to undergo psychotherapy. The judge ruled that Hearst must undergo psychotherapy, set a trial for 3 months later, and sealed the report. Hearst underwent the psychotherapy during her time in jail while a trial was pending. In February of 1976, Hearst went to trial. She now had a second defense team and, as expected, a new strategy for defense. F.L.E. Bailey was her new lead attorney. He rejected any traditional psychiatric defense, insanity, or diminished capacity, rather a defense of duress or coercion. Bailey believed that the court-appointed experts, along with the other 2 non-court-appointed experts, would support his defense. Bailey's strategy was to use the testimony of the experts to testify Hearst had, in fact, been brainwashed by the SLA, and that this is a form of cohesive persuasion. The strategic move backfired in the end. Expert 1 was a professor of psychiatry at the UCLA. He explains the behaviors and links of her sickness and says that it's a pretty classical example of what we call persuasion. Objection from the prosecutor. He explained that the testimony was not on grounds, and he objected. Judge allowed the testimony to stand, but required any new testimony be given in all question and answer format. The second expert, Martin Orme, a psychiatrist at the University of Pennsylvania, his evidence suggested that psychiatrists are not very good at telling the truth or recognizing the truth. This was a statement that he made in court under oath in a case previous to this one. He undermined his credibility when he acknowledged during cross-examination that he did not want to contact the government. Expert 3, Lifton, professor of psychiatry at Yale, admitted on cross-examination as well that the documentation directly relating to this case, including security footage and audio recordings, were not looked at during his proceedings, and neither one of them understood the exact reason on why she could or could not be found to stand competent during this trial. Both experts selected by government concluded that Hearst had not been acting under duress or coercion at the time of the robbery. The prosecutors used experts Fort and Kozel. Both explained her actions and the behaviors after the kidnapping, but before the other crimes occurred, including the crime of robbery, but not limited to the getaway driver and bomber. Fort painted Hearst as a willing participant of the SLA. She had consensual sexual relations with other members of the SLAs. Fort explains Patty's behaviors during the sporting goods store shooting to carry out those complex acts, not have taken the obvious opportunity to walk away from the van or drive away with it to be free. Putting that together, I would say it points in the opposite direction of having any kind of mental health illness, but also in the opposite direction of being under any kind of duress. Kozel states, I think she walked into that bank voluntarily in order to participate in the robbery of the bank. It was an act of her own free will. After only 1 day of deliberation, the jury convicted Hearst, and she was sentenced to 7 years in prison. The improvement on the criminal justice system regarding this case is better understanding and identifying the victim's mental and emotional state during, before, and after trial, setting precedents on legislation and how we can use previous court orders and issues in determining how we move forward, and the due process of how we treat these types of criminals and all criminals.